This court is in session. God bless the people of this country. Today, judge presiding is Miss Explain It. The defendant, Mr. Eviction, is in court. Matter, eviction of a tenant. Cause of action, breach of the Rent Restriction Act.
Mr. Eviction, why are you here today?
Your Honor, I rent my place to Mr. Sack for 3 years now. And about 2 years now, I don't get no rent.
So the rent is in arrears?
The rent not in anywhere, Your Honor.
I did not say the rent was anywhere. I said in arrears. That means he owes you rent money.
Oh yes, Your Honor. Him keep telling me it's because of COVID why him can't pay me. But COVID never there last year. In March COVID come.
So why are you here? What did you do?
Your Honor, I asked him for rent many times and him ignore me. And while I tell him get out, him say him not coming out. So I first get somebody to cut off the light, so him not have no light.
What else did you do, if any?
After that didn't work, I pull off the door. And my door, my yard, my house.
So where is the door now?
Me hide it, Your Honor, cause me don't want him find it and put it in the shed in my backyard. Him then call police for me. Police say me if put on back the door, cause him can't take me for court. And I must go to court and let the court deal with it. But when me go in the shed, out the door, when me hide the door, me couldn't find it. I go to him thief it. So him go court take out a summon. That a piece of paper that say you must come court on a certain date.
Who served you the summon?
Same man, Mr. Sack. I him give it to me.
Mr. Eviction, what you did was wrong. You cannot forcibly evict a tenant that way. You will find yourself on the wrong side of the law, as you do now. You cannot do such things as changing the locks on a door, taking out windows, or disconnecting utilities. To remove a tenant from his property is against the law.
Your Honor, but he owe me money.
Mr. Eviction, listen to what I'm saying to you. Even though the tenant owes you money, you cannot just do as you like with the property. He still has rights. You are to go to the parish court, lodge your complaint, tell them how much money the tenant owes you and what you want. Whether you want him to pay up the rent or you want him to pay up the rent and leave your place. The clerks at the court will assist you in writing up a notice to quit. This notice will give the tenant at least 30 days before the rent is due and should expire before a new rent period begins. It will also state the reason the tenant is required to vacate the premises and the date by which he or she should do so. It is important to note that if a landlord gives the tenant notice to vacate the premises for arrears of rent, the landlord accepts, and if the landlord accepts payment of the rent from the tenant before the expiration date of the notice is no longer valid and the tenant will have to get a new notice. You are also required to serve the notice to quit. You are to ensure that the notice to quit is properly served on the tenant. The notice may be left with any person who is 16 years or older at the rented premises, or it may be affixed to the door of the premises if no one is present to accept the service. If the tenant remains in possession of the premises after the notice expires, you can then commence proceedings in the parish court or the Supreme Court. Since the rent owed to you is under $1 million, you will need to take the matter to the parish court. You should try and obtain an order for rent arrears and possession of property by lodging a plaint. A plaint is a complaint that you make to the clerk about what has happened to you. And if you want the tenant out of your place as he is not paying, and the clerk will assist you by writing up a summon and a plaint just like the one you got, requesting the tenant to attend to court. That document you will serve on the tenant. If the tenant does not attend court, the judge will give you a date for default judgment. That means that because the tenant does not turn up to make his case before the court, the judge will ask you to present your evidence, and if satisfied, make an order in your favor. If the tenant attends court and the court indicates that he intends to defend himself, a further date will be scheduled for the matter to be tried. If the tenant attends court and indicates that he intends to defend the claim, a further date will be scheduled for the matter to be tried. But today, Mr. Eviction, you're not here as a plaintiff but as a defendant because of your illegal actions against your tenant. The Act provides that except under an order or judgment of a competent court, no person shall forcibly remove the tenant from the rented premises or do any act, whether in relation to the premises or otherwise, which is calculated to interfere with the tenant's quiet enjoyment at the premises or to compel him to deliver up possession of the premises. The Act goes on to state that where there is evidence that a landlord is guilty of carrying out the acts mentioned above without a court order or judgment in place, he could face imprisonment for up to a maximum of 12 months. Now, you have disconnected the electricity and you have taken off the door. Is the room still without a door?
Boy, him put on the door, Your Honor. I can't find the door.
What about the electricity? Is it still off?
Yes, Your Honor. Me never put it back, you see.
I am ordering you, Mr. Eviction, to reconnect the electricity, and you are going to pay back Mr. Sack $30,000. The cost for him to buy the door and to pay someone to put the door back on. The court will also fine you $50,000 to be paid in 2 weeks or 2 months imprisonment.
$50,000, Your Honor. I look back just myself on the road, but boy, alright, I will do it.
That's the order.